Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, April 3rd, 2025. We're on voting list number 23. And we're going to start off with House Bill 767.
House Bill 767, for a refresher, is the bill about requiring a certain notice before eviction. As amended yesterday, you have an amendment in your packet that is updated with all of the discussions based on the voting session yesterday. It's the same, except if you look on page 7 of the reprint, starting in line 26, now, after a court has issued a warrant of restitution, the landlord shall at least 6 days before the scheduled date of repossession set by the sheriff provide the written notice. And then if you flip to page 8, in line 13, this is the suggestion that Senator West made in the last voting session to say that the notice has to only have the initial scheduled date of eviction. And then if you turn to page 11, it allows local jurisdictions to pass legislation that could increase the minimum number of days up to 14 days, or they could do the opposite and go down to 4 days.
Anyone who would speak on this who was on the work group? So good.
Move the
amendments. Okay. So in a motion to move the amendments, has it been seconded?
The work group
Seconded.
had advocates on both sides with us, and when we left, everybody was in accord.
All right. Motions for favorable with the amendment. Second. All right. Is everyone okay being recorded in the affirmative on House Bill 767? Senator Fulton is down. What's up? All right. With that, House Bill 767 with the amendments passes. It's a final tally. 8-1. All right, we're now going to move on to House Bill 243. I'm sorry, yes. Oh, my apologies, yes. We'll take the House Bill, Senate Bill 442. Same, we'll just conform it to what we just did with the House bill. Motions for a favorable on Senate Bill as amended. It's been seconded. Does everyone want to just record the same vote? Yes. Okay. Yeah. Apologies, sorry about that, Senator. All right, we'll now move on to House Bill 243.
House Bill 243 establishes that certain provisions of law governing adoptions, including those requiring the issuance and service of a show cause order on a prospective adoptee's parents and for a petitioner's spouse to join in the petition, do not apply if the prospective adoptee is an adult.
Motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? Okay. All right, House Bill 243 passes unanimously. We're now going to move on to some delegation bills. We're going to go to House Bill 360. That's John.
House Bill 360 requires the registration of all cooperative housing corporations, condominiums, and homeowners associations in Prince George's County. The Prince George's County Executive must set an annual registration fee in an amount sufficient to adequately fund the cost to establish and administer the administrative hearing process by the Office of Community Relations. The bill also permits the county to establish certain additional fees and prohibits unregistered or falsely registered persons from accessing the county's administrative hearing process.
Hey, John, sorry, you know what? I just realized that no Prince George's County senators are present at the moment, so let's go on to House Bill 45.
House Bill 485 modifies and expands provisions relating to the St. Mary's County release programs for individuals in the custody of the Sheriff of St. Mary's County.
We do have a delegation letter. There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, House Bill. Yes, yep, we're going to that next. House Bill 485 passes unanimously. We'll now move on to House Bill 492.
House Bill 492 authorizes the Frederick County Director of Human Resources to request state and national criminal history records checks for a prospective or current employee or volunteer of the county. The director must submit fees and 2 complete sets of prospective or current employees or volunteers' fingerprints to the Criminal Justice Information System Central Repository.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, House Bill 492 passes unanimously. We'll now move on to House Bill 808.
House Bill 808 establishes certain notice requirements for landlords of real property in Howard County that require tenants to pay all or part of an annual charge as part of the rent. An annual charge means the charge assessed by the Columbia Association on residential or commercial real property in Howard County that is subject to Columbia Association covenants.
Motions for a favorable. It's been seconded.
808.
All right, it's been seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 808 passes unanimously. We'll now move on to House Bill 988.
House Bill 988 authorizes the Transportation Authority to place and use speed cameras on Maryland Route 200, which is the intercounty connector in Montgomery County. The State Highway Administration is required to provide the authority with access to its speed camera vendors and contracts to assist the authority in planning and implementing the speed cameras required by the bill.
We have a delegation vote. It was unanimous in delegation. We have a delegation letter. It's motion for a favorable. Second. Is everyone okay being recorded in the affirmative? All right, so 2 down. Senator Folden's down and Senator McKay are down. Is it 9-2? Oh, that's right. All right, House Bill 988 passes 7-2. Now move on to House Bill 1032.
So as it came into the Senate, House Bill 1032 authorizes the use of stop sign monitoring systems on state and local highways in school zones in Baltimore City and Montgomery County. There is an amendment in your packet, which is number 933422. The amendment removes Baltimore City from the bill, and it limits it to Tacoma Park in Montgomery County. Just kind of as a note for the committee, Senate Bill 808, which was passed by the committee and I believe is now in the House, made a couple of changes to the stop sign monitoring program in Prince George's County. Those changes would apply to the Montgomery or the Tacoma Park. Basically, this just adds to the Tacoma Park to that existing program. So the changes that were made in 808, if they're enacted, would also apply to Tacoma Park.
Just to be clear, can you say one more time that it only applies to Tacoma Park?
Yes, so the bill that you have before you now only expands the program in Tacoma Park, Montgomery County.
All right. There is a delegation letter of support. I'm going to adopt the amendments, and then we'll have the bill before us as amended. Is everyone okay adopting the amendment? And Senator Sidner has a question.
And I'm assuming the bill that you were talking about was presented by Senator McCray that had the stop sign cameras for his district?
No, I was sorry if it was a little confusing. I was referring to Senate Bill 808, which I think was Senator Augustine presented. It dealt with, because this program currently exists in Prince George's County only. So the way this bill is drafted, it simply adds now with the amendment Tacoma Park to that exact authorization. And I was simply pointing out that the committee, in considering Senate Bill 808, had made a couple changes to the way that program operates in Prince George's County. And just noting for the committee that those changes would also now apply to the program in Tacoma Park. And I believe the committee also did approve a bill for Senator McRae's district, so the changes would apply to that program as well.
Thank you.
All right, motions for favorable with the amendment. Seconded. Is everyone okay being recorded in the affirmative?
Or,
Tacoma Park only, stop sign, but,
is this on the bill or on the?
on the bill. So Senator Fulton's down, Senator Love is down, and Senator McKay is down.
6-3.
6-3.
So it's 6-3, so if we technically got one more, it would pass, right? Because it goes by,
It would be 5-4.
It'd be
then.
5-4.
yeah, but it has to, don't we need 6 affirming votes?
No,
You've seen a majority.
majority.
I thought you had to fix that.
House Bill 1173.
House Bill 1173,
Ask Sandy if there's a letter, I don't know.
1173. What was the date? Let's just skip down to House Bill 1236.
House Bill 1236 authorizes a municipality in Queen Anne's County to decrease the maximum speed limit to not less than 15 miles per hour on a highway without performing an engineering and traffic investigation.
Thank you, Mr. Chair. I don't think I need to reiterate how much I love speed camera bills. On this bill, and I'm going to ask counsel because I don't know off the top, and I don't want to belabor this, but it says about without conducting the study, but does it in there reference that the results of the study either A, have to be published, or B, have to justify the reduction in the speed limit? Because right now, the state law only requires you to conduct a study, as I understand it, and regardless of what the results of said study are, you can still adjust it as long as you conducted it.
So the statute, which is 21-803 of the transportation article, does say that the local authority determines that any maximum speed limit specified in the subtitle is greater or less than reasonable or safe under existing conditions on any part of a highway under its jurisdiction. So that is all, that's what's in the statute about the contents of the study.
But can you say one more time what it says about the study?
Yeah, so it says, if on the basis of an engineering and traffic investigation, a local authority determines that any maximum speed limit specified in this subtitle is greater or less than reasonable or safe under existing conditions on any part of a highway in its jurisdiction, it may establish a reasonable and safe maximum speed limit for that part of a highway.
So how does that, so where does that compare to vehicle law where when you take your driver's examination and all these wonderful things, it talks about that speed limits are 25 miles per hour, no less than in residential districts and no lower than 30 miles per hour in business or industrial areas?
So there are some limitations on what may be done on the basis of that investigation. And specifically, the local jurisdiction may decrease the limit at an intersection, increase the limit in an urban district to not more than 50 miles per hour, decrease the limit in an urban district, or decrease the limit outside an urban district to not less than 25 miles per hour.
Yeah, that's what I mean.
Yeah.
So the law is, it sounds like is contradictory because, and maybe I'm missing it, so please let me know, but it says that not less than 25 miles per hour, but we have jurisdictions that are trying to go down to 15 miles per hour.
Correct. This would be a separate authorization that would allow them to go down to that
So,
specific.
okay, let me ask you this then. So this is an authorization for Queen Anne's County to be able to go down to 15, right? So by what you're telling me with the current law then, is it acceptable for a jurisdiction who does not have state authority to go down to a speed limit less than 25 miles per hour?
In an urban district, yes, because you can go down, there is no limitation on the decrease in an urban district.
But in a rural?
In a district that is outside an urban district, it is not less than 25 miles per hour.
Interesting. Okay, so, okay. Thank you for that, Josh. So nowhere in there, it references that the results of the study are to be published, and it doesn't require that, it just says based that they do it, so really it doesn't matter. If they say one person, that's a need. By the way it's written, as loosely as it's written, they could be like, well, one person came speeding through, so we think it's a need.
There is no particular required form for the study, nor is there a requirement that it be published.
Well, I would, Mr. Chair, I would like to see, I think we should give consideration that since we keep going to these studies and trying to, and use those as justifications for some of these municipalities to reduce the speed limit, I think it's important that they show that there's a justification for it, not that it's a lowering of the speed limit and then subsequently posting speed cameras around for revenues. I understand the safety component, and I'm in support of that, but if it's truly a safety component, why wouldn't these jurisdictions want to have the speed study or traffic study conducted and those results be able to be published for public review? No, I mean, I don't need to hold the bill. I'm just saying, can't we just put an amendment on there that says, or on these, I mean, yeah, that it requires that any of these adjustments be shared with the public.
Thank you, Mr. Chair. I hear the senator's point, but that's not this bill. This bill is to decrease the maximum speed limit to not less than 15 without an engineering and traffic investigation, which Baltimore City, Anne Arundel, Montgomery all have. Calvert has it on Lore Road. So, I mean, I hear that, but I think that's a different bill.
to lower speed limits, would it be that costly to have it posted, not by hard copy, just have it posted and available for the results of that study for public review?
Since it's not currently public, that would be something you would have talked to Steve about creating a public forum.
Yeah.
Fiscally, I'm not sure exactly how much it
All right.
Maybe we can follow up and do an inquiry on that, but if not, then you probably expect a bill coming next year, but.
Yeah.
All right, so with that, motions for favorable on House Bill 1236.
Thank you, Mr. Chair.
Yeah, that's good. That's good discussion. It's been seconded. Is everyone okay being recorded in the affirmative? Senator Fulton is down. 8-1. All right, let's go to House Bill 1173. Yeah.
House Bill 1173 authorizes the placement of speed cameras on highways in Montgomery County that have been identified in a municipality's, the county's, or the state's most recent strategic highway safety plan or Vision Zero plan as having a high risk for motor vehicle crashes that result in serious injury or death. There is an amendment in your packet, which is number 693920/1. The amendment simply clarifies that revenues collected by municipalities in Montgomery County, for those revenues, the remaining revenues after cost recovery must be spent on roadway and safety improvements in that municipality specifically, rather than the county as a whole.
All right, I'd like to adopt the amendments. Is everyone going to adopt the amendments? Now the bill's before you as amended. Motions for a favorable with the amendments. It's been said, Senator Love has seconded. All right, Senator Fulton is down. All right. What was the final tally on that? 8-1. 1173. Got it. Yeah, here. Oh, okay, sorry, my bad. No. All right, now we're on House Bill 1227.
House Bill 1227 alters existing requirements related to permitted locations of school bus stops in Montgomery County.
It's been motioned for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? 1227. Take your time. That's a unanimous vote. All right, now we're going to go on to House Bill 1293.
That you just moved with the high risk, isn't that similar to the one that we talked about? Same language of that SHA bill?
Oh, yeah, the high safety corridor bill?
Safety corridor.
Yeah.
Is it not on here anymore?
Do we still have that in the?
Yeah, it's like three.
It's on here.
It is?
HB 348, SB 520.
Which one is it?
HB 348, SB 520.
Yeah. All right, you want to move that? You want to move it now? Same thing?
Well, wasn't there a lot of amendments that came in on that?
Yeah. We'll get to it.
Okay.
House Bill 1293 establishes the Neighborhood Services Unit within the Office of the Sheriff of Baltimore City and requires the unit to work in partnership with the Board of License Commissioners of Baltimore City to enforce the alcoholic beverages laws of Baltimore City and perform any other duties as directed by the sheriff. The unit and board must enter into a memorandum of understanding that specifies the respective roles and responsibilities of the parties in connection with the partnership. In addition, the bill expands the authorized uses of revenue generated from certain surcharges under the under the bill on filing fees collected by the district court in Baltimore City to include the work of the unit. There is one amendment in your voting packet. Rather, there's a reprint of that amendment. The amendment specifies that the memorandum of understanding that the board enters into with the unit needs to specify the funding source for the unit, and that correspondingly provides that the unit shall enter into a memorandum of understanding with the board that specifies the funding source for the unit. And that is the only change, or those are the only changes by the amendment.
Yeah, going for
All right, let's do this. So Charles, you want to move let's move the amendments. Is everyone okay adopting the amendments? All right, now the bill's before you as amendment. Further discussion? No, yeah, all right. Just for the, I got it. So it came out of delegation. We got a delegation. For the record, submitting that there is a letter of concern from the mayor, but the delegation has moved forward with suggesting that we do it. So I just want to have that for the record. So motions for favorable. It's been with the amendments. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. Okay. So Senate Bill 1293 with the amendments passes unanimously. Well, now, so John, we're going to go back to House Bill 360.
House Bill 360 requires the registration of all cooperative housing corporations, condominiums, and homeowners associations in Prince George's County. The Prince George's County Executive has to set an annual registration fee in an amount sufficient to adequately fund the cost to establish and administer the administrative hearing process by the Office of Community Relations. The bill also permits the county to establish certain additional fees and prohibits unregistered or falsely registered people from accessing the administrative hearing process until they are properly registered.
What's your pleasure? Prince George's County bill. We're on
360.
House Bill 360. We have a delegation letter. There's been a motion for favorable. It's been seconded. Just waiting for it.
Okay. I mean, I'm voting down.
Okay, so everyone is everyone is saying yes in the affirmative. Senator Folden is down.
Trust me, I'm gonna be done with it. Yeah, that's famous last words. You voted 360? We did. And I was down?
You're down.
Thank you, Mr. Chair. Could we go to House Bill 674 by Delegate Kaufman? And I would make a favorable motion on behalf of that bill.
All right, excellent. Jamie, go ahead and read it into the record, but there's been a motion for a favorable and it's been seconded, but let's go ahead and read it into the record, then we'll take a vote.
House Bill 674 prohibits a person with the intent to conceal a crime from knowingly and willfully dismembering, destroying, removing, burying, disposing of, or obliterating by any means any portion of human remains. The bill also prohibits a person from aiding or abetting another in the commission of such an act. A violator is guilty of a felony and on conviction subject to imprisonment for up to 5 years. A sentence imposed for this crime may be consecutive or concurrent with any other sentence imposed for any other crime based on the act establishing a violation of these provisions. There are no amendments in your voting packet.
There's been a motion for a favorable that's been seconded. Is there any further discussion? Sure, Senator Sidnor.
Let's see, its crossfire was 394, correct? Yeah. And the intention is to take it as is, not changing to homicide or anything. So you said there was no amendment?
There are no amendments.
Okay, thank you.
Is everyone okay being recorded in the affirmative? Do we need to take a roll call? All right. Everyone, so House Bill 674 passes unanimously. We'll now bring up the cross-file, the Senate cross-file, which is Senate Bill 394. The motion's for favorable. It's been seconded. Is everyone okay being recorded in the same posture as the last bill? All right.
Which was unanimous.
Which was unanimous. Senate Bill 394 passes unanimously.
With the prosecutors, I worked with the Department of Health, I don't know. So it's a good little bill with no opposition, so it's House Bill 1209. I'll be glad to explain it if nobody, I think almost everybody here is familiar with it, but.
House Bill 1209, Josh will read it into the record, then we'll take a vote.
House Bill 1209 alters statutory provisions that govern in certain circumstances involving the fatality or near fatality of a child, the required disclosure of reports and records. The bill requires a local director of social services or the Secretary of Human Services to disclose within 30 days of receiving a request certain information concerning child abuse or neglect in those cases.
All right, Senator James has moved the bill. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right. House Bill 1209 passes unanimously. House Bill 470 first. Delegate McComas, we moved your bill.
Oh, yes, that just got.
Yeah. Unless you want to hang out with us, but that's cool. Good to see you.
So, House Bill 470 makes several changes to laws pertaining to registration plate covers. The bill alters the definition of those covers to exclude clear items. It prohibits a person from advertising for or promoting the sale of an unlawful registration plate cover by falsely claiming that the cover is lawful in the state, and establishes that a violation of this prohibition is punishable under the Maryland Vehicle Law and as an unfair, abusive, or deceptive trade practice under the Consumer Protection Act. The bill also alters the existing offense of obscuring your license plate registration, your registration plate, by prohibiting a person from obscuring or modifying a plate in a manner that may prevent identification, rather than the current statutory requirement, which requires intent to avoid identification. And finally, the bill establishes that a police officer may enforce that violation only as a secondary offense.
Oh, that was a good bill. They did a lot of good work on it. Senator Sidnor.
No, and I'll say it, and similar to what I said in the hearing, I like the bill, but the concern that I had was the line 29 and 30 on page 3. So I will likely vote for the bill, but just wanted to make certain I said that.
So I know we went around and around on this in the House, and the challenge is proving intent to avoid. And so what they landed on was taking out the intent but making it secondary, as Delegate Ziegler said. I mean, I hear you. We really struggled with the intent part, but that's where they landed. Mm-hmm.
So there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. Excellent.
How about SB 1007?
House Bill 470, hold on. We're going to do also Senate Bill, is this the cross file? Yeah. Just fine. Three, is it the cross file?
Yeah, Kagan?
Yeah. I know it's a little bit more work, but like.
So Senate Bill 322 is the cross-file to House Bill 470, so I think the motion would be to conform to House Bill 470.
Seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 322 passes unanimously. House Bill 877.
House Bill 877 extends the termination date of the Prison Education Delivery Reform Commission by 3 years. The bill also extends by 3 years the deadlines by which the commission must submit their reports.
All right, motions for favorable.
1 second.
Okay. 877. All right. House Bill 877 passes unanimously. House Bill 1116.
House Bill 1116 renames the State Clearinghouse for Missing Children to instead be the State Clearinghouse for Missing Persons. It transfers its statutory provisions from the Family Law article to the Public Safety article and further establishes that the duties of the State Clearinghouse for Missing Persons include the receipt, collection, and distribution of general information and annual statistics regarding missing persons and coordination of law enforcement agencies and other interested persons or groups within and outside of the state regarding information on persons who have disappeared from or are thought to be located in the state. Other conforming changes are made and reflect the expansion of the clearinghouse to include all missing persons rather than children.
So motion's for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 1116 passes unanimously. Huh? House Bill 628. Is she still chair rules, right? Huh?
Yeah.
Hence, yes.
House Bill 628 requires the State Highway Administration in determining funding for the construction and reconstruction of sidewalks and bicycle paths to prioritize projects that are or are adjacent to highways that are subject to a complete streets policy or other similar Vision Zero program.
It's been a motion for favorable. It's been seconded. There's discussion. Senator Folden.
This is that this bill does not affect the Transportation Trust Fund, but that local government operations and finances may be affected because this is something else that would then be passed through as a requirement to the local governments. I mean, this is if this isn't a local bill is what I'm saying. This is a statewide bill that's going to have impact on local government.
This is, yeah, a little information.
Just to explain, I think the potential impact is it may result in different projects being funded, which may have the effect of, the project may be in one local jurisdiction or another. So that's, I think, the reason for that language in the fiscal note.
Okay, let me ask again, Josh, because I don't know that I fully grasp what you just said there. So is it not requiring them to do it, or that when they redo sidewalks or construct sidewalks that there would be like a new compliance measure?
The projects themselves are unaffected. I think what the fiscal note is pointing at is that it may cause SHA to prioritize funding for one project or another. And if, your local jurisdiction has one of those that has, the funding may be shifted away from it, that could affect the local jurisdiction's operations. But the substantive requirements for the actual programs are not being changed by the bill.
Take a second to read Mako's testimony.
So all right, that's what I'm looking at. Thank you.
What Mako said. So I'm reading the letter from the Department of Transportation, and it says the intent of House Bill 628 is unclear. Some may interpret the bill's requirement to prioritize funding for complete street or Vision Zero as requiring SHA to fund only sidewalks ahead of
other asset classes. Do we, this is right at the bottom of, what is the, for the record, I'm just curious, I mean, again, I intend on voting for the bill, but for the record, the intent, do you recall what the intentions was that the sponsor had noted in her testimony? See, I don't think I was here either.
Let's try it. Motion for, you want a motion? Been a motion for favorable, let's do a roll call. No, there has been a motion for favorable, it's been seconded, but if you'd like to comment.
Correct, we are not for or against this bill. We just want to make sure that, the intent is clear, that we do not want to change what is being prioritized. We just want to make sure that it is clear what the priorities are, but not to change it within the CTP as putting these projects above other safety projects.
I don't want to hurt a county unknowingly, including my own, but so the MACO is saying something that might undermine what you hope what you believe, which is this bill would give counties that have Vision Zero programs priority in receiving state funds or program support for sidewalk and bicycle pathways. So I don't know if, does every county have a Vision Zero program to your knowledge? Do you know that?
To my knowledge, I do not know if every single county has that program.
Now, I don't mean to put you on the spot, but
That's okay.
I'm not sure Mako's confident either, because this is just a letter of information, but it seems to interpret that it would give some priority to these Vision Zero counties, and you all are you're hoping that whatever this bill does, it doesn't change sort of the CTP's priority lists as they currently stand. Is that correct?
That is correct.
So what we have is a
Right.
situation where you hope that Mako thinks
Correct.
maybe it could, but I don't even know if Mako are experts in this area.
Right,
either.
so is it being added as a priority? Or
Right.
is it being placed above others as a top priority?
Right, okay.
So that is our
And
question.
we don't have anything from the Attorney General, or anything else. Is Mako here?
Okay.
It's not going to affect.
Vice Chair Waldstraker,
Yes.
Senator Sidnor.
Yes.
Senator West,
Yes.
Senator Muse.
Yes.
Senator Folden,
No.
Senator James,
No.
Senator Henson,
Yes.
Senator Love,
Yes.
Senator McKay,
Yes.
Senator Charles,
Yes.
Chairman Smith.
Yes. She said no. So 9-1. I mean, 9-2. All right. All right, we're now going to go on to House Bill 658 because that has to go over to Triple E.
House Bill 658 alters the Juvenile Services Education Board by 1, staggering the terms of appointed members, 2, imposing a 2 consecutive term limit on appointed members, 3, authorizing the Secretary of Higher Education and the State Superintendent of Schools to assign a designee to serve in their place on the board, 4, reducing the number of required meetings from once a month to 10 times a year, but not more than once per month, and 5, by authorizing a majority of members, the chair of the board, or the Secretary of Juvenile Services to call special meetings of the board that would not count towards that monthly limit.
All right. It's been a motion for a favorable. It's been seconded. Do we need a roll call? Is everyone okay being recorded in the affirmative? Everyone's good? All right. House Bill 68 passes unanimously. All right, we're going to go House Bill 210.
House Bill 210 establishes a new offense of mail theft and corresponding penalties for mail theft violations. Under the bill, mail theft refers to violations of the general theft statute under 7104 of the criminal article involving the theft of mail or the commission of specified acts related to the theft of mail involving the use or possession of an arrow key. A sentence for conviction for mail theft may be separate from and consecutive to or concurrent with a sentence for any other crime based on the acts establishing the violation. The district court has concurrent jurisdiction with the circuit courts for felony mail theft, and a police officer or a law enforcement agency may use facial recognition technology to investigate the commission or attempted commission of mail theft. Finally, the bill repeals the existing offense of taking and breaking open a letter without permission. Instead, the bill prohibits a person from knowingly and intentionally opening mail addressed to another without the permission of the other or the other's authorized representative or designee. Violators are guilty of a misdemeanor punishable by imprisonment for up to 1 month and/or $1,000 maximum fine. The bill provisions are very similar to those found in Senate Bill 410. Major distinguishing features between those two bills are the Senate version had a graduated penalty structure that was based on how many pieces of mail were stolen during the commission of mail theft. Additionally, this bill has a provision relating to facial recognition technology and the use to investigate mail theft.
We're gonna hold this one. Yeah. We're gonna hold this one. All right. House Bill 260.
That's not, that's not. I can juggle.
House Bill 260 reduces penalties for offenses involving drug paraphernalia and controlled paraphernalia. Additionally, the bill repeals the prohibition on a person using controlled paraphernalia to administer a controlled dangerous substance.
I thought it was actually a pretty good bill. Is motion for favorable? It's been seconded.
260.
Is everyone okay being recorded in the affirmative? Senator Folden is down. We're going to go to House Bill 646.
House Bill 646 extends the termination date of the task force on the creation of a division of returning citizens and expanded reentry services from 2026 to 2027 and makes a corresponding change to the deadline for the submission of the required report of the task force.
Yes, I move favorable. This was originally my bill, and they need more time to complete their work.
Need more time to what?
Complete their work.
All right, so there's been a motion for favorable. It has been seconded. Is everyone okay being recorded in the affirmative? Okay. House Bill 646 passes unanimously.
system.
House Bill 814.
House Bill 814 requires the Department of Juvenile Services to report to this committee and the House Judiciary Committee on or before October 1, 2025, and each October 1 thereafter, on their efforts related to pre-delinquent programs, including youth service bureaus.
So, all right, Senator Fulton.
Bill does what again about the services?
From the department to Judicial Proceedings and the House Judiciary Committee on their efforts to promote pre-delinquent programs, including youth service bureaus, their efforts to collaborate with and provide technical assistance to local governments regarding youth service bureaus, and an assessment of the programs and activities conducted by youth service bureaus, and any other efforts they're making to prevent youth offenses.
Okay, so we have this one which talks about efforts, but we don't have one that we spoke about before where we were talking about outcomes of those programs. So we talked about what initiatives they're doing, which is what they're getting funding on, but we never talked about requiring them to give a report on the outcomes of those initiatives.
Last year, as a part of the juvenile reform bills that we did, not this year, but last year, we set up a committee that's comprised of people from DJS, experts all throughout the whole continuum of youth's interaction with the justice system. And that committee is going to evaluate those programs. It was just set up like in October, and they haven't, they're supposed to meet 3-4 times a year, and then we're going to report back to us and the governor. We have not, since that was just recently stood up, we have not been in receipt of those reports yet. So there is an accounting mechanism, it's just forthcoming, but it's a little separate than this, but there is an oversight and accounting mechanism set up. We also set up the Office of Children in the governor's office. I think we dropped $40 million into there. They're also going to be collaborating and exercising oversight capacity. So we're going to have a lot more information next year. You also know we did the OPEGA report, which you had a briefing on earlier, but there's a lot more scrutiny and information forthcoming next year.
What's there? No, it's not necessarily germane to this, but was there any staffing questions or reports coming from them on juvenile on staff assaults?
The Juvenile Justice Monitor actually releases, I think, a quarterly report, which actually does have a lot of, I can share with you, they do track assaults on youth on staff in each facility that DJS operates.
Well, that ought to be shared with everybody in this committee, because if they look at like in Green Ridge, every single staff member has been assaulted. According to the people who work in my district where this is at, it is out of control.
So we also stood up the Correctional Ombudsman, which now the Juvenile Justice Monitoring Unit is under, and they will also be reporting to us. So that's also a relative that was just stood up last year. So we're just, all that information is kind of still forthcoming, but I think that's very good.
And normally this doesn't happen at church. But between Sunday school and the second service, I had 3 employees come to me and say, what is happening? What are you guys doing? We are suffering here. No one wants to work here. Everybody is fearful. Got a lady who's going back to corrections because she feels it's safer going back to corrections behind the fence.
I used to get copies quarterly of these reports. I haven't received them in a couple of quarters. And I did not receive this year the big, thick binder that DJS puts out with all their statistics. So could I suggest that staff contact DJS and ask them to put each member of our committee on their distribution list for the annual report as well as for the quarterly reports? What's that?
It's called the Data Resource Guide.
Yes, right. We should all receive that, and we should all receive the quarterly reports as well. Quarterly reports, as I recall, came in by email. Right. I used to. I haven't recently. So, just to keep us abreast of what's going on, I think it's important we receive this information.
All right, the bill's before you. It's been motions for a second. There's a motion for favorable and it's been seconded. Is everyone okay moving on the bill? Is everyone okay being recorded in the affirmative? House Bill 814 passes unanimously.
House Bill 273 prohibits a landlord for residential leases from charging a penalty for the late payment of rent that exceeds 5% of the amount of the unpaid rent due for the rental period for which the payment was delinquent.
Good. Motion's for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 273. All right, we're going to go to House Bill 302.
House Bill 302 expands statutory requirements that are applicable when an application for a statement of charges is filed against certain professionals alleging an offense committed in the course of executing the professional's duties to include adult protective service workers and child welfare caseworkers.
It's been a motion for favorable and seconded. Is everyone okay being recorded in the affirmative?
1 second.
All right.
No, I was just asking, again, I don't think I was here for this particular hearing, and so I'm going through the testimony now and just was asking council just to, again, explain what the bill is intended to do.
So currently, for law enforcement officers, emergency service personnel, and educators, if there is an application for a statement of charges against them for some offense they had allegedly made in the course of executing their duties, before that can be filed, it has to go to the state's attorney to investigate the circumstances of the matter and then make a recommendation to the district court commissioner. So this is adding to that list of professionals. This is adding adult protective service workers and child welfare caseworkers to that list.
So everyone's okay being recorded in the affirmative? House. For 1 second. Okay, hold on. Let me just get 301 and then we can come and try.
302, everybody.
All right. House Bill 301.
Oh, okay. Thanks, Sandy. House Bill 301 alters the information that must be asserted and is required to be included in a sworn affidavit submitted by a law enforcement agent for the initiation of a forensic genetic genealogical DNA analysis and search, or FGGS. Under the bill, a sworn affidavit must be submitted by a law enforcement agent with approval from a prosecutor from the relevant jurisdiction, asserting that the identity of the perpetrator is unknown, instead of that reasonable investigative leads have been pursued and failed to identify the perpetrator.
The reasoning behind this was, remember that, I think that woman was murdered in your district. Was it 16 or was it 18? Yeah. Senator Love.
As I recall, the problem that this bill is seeking to fix is that law enforcement is only applying it to cold cases. I have some questions in my notes about, rather than making these changes, is there a way we can clarify that it doesn't only apply to cold cases? I'm very concerned about the use of these databases. And if I understand the original sponsor's intent, it wasn't supposed to be for cold cases. So is there other language that we could use that might clarify that?
So I had the same thought during the hearing. I'm fine with the language as it's drafted in the bill. And I think the sponsor is thoughtful about how he goes about drafting. But during the hearing, I thought that perhaps, some of that, who's the analyst on this? Like, nothing in this statute shall be interpreted language that we occasionally but don't frequently use could be useful to provide guidance to the people who are reading the statute. Just an idea.
I mean, if that's what the committee wanted to do, sort of going along that line, you could say nothing nothing in subsection B shall be interpreted to require that a law enforcement agency have exhausted all investigative leads. Because I think the differentiation there is that what the statute says is that they need to have taken reasonable investigative leads and failed to identify the perpetrator. But if my understanding is correct, that perhaps that's being interpreted as they needed to have effectively exhausted every possible lead, and therefore you have a cold case, and that's what, yeah.
So to my point, and Senator Love is correct, when we put this language together, it wasn't intended that you was going to be some cold case, but what we were also trying to balance was that this wasn't going to be the first thing that law enforcement were going to go to, because it's very invasive of people who aren't they call it the putative perpetrator. The interpretation, I think, that law enforcement is having, that it has to be some cold case, that is certainly not right. But because this is new technology or a new tool that law enforcement was using, there was still the idea in our discussions that you wanted them to continue doing the type of police work that they do, and then to the point where they can't, that they had this tool available. I don't know how you capture that if they're interpreting this as it has to be a cold case. I don't recall that being anyone's intent on our calls.
Just sort of to go back to that, it's maybe a distinction between the idea that, the bill says that they need to have taken reasonable steps to investigate before they get to this point. But it seems that at the hearing, the suggestion may have been that it's interpreted as they needed to have exhausted not just reasonable investigative leads, but every investigative lead that they could think of before they get to this step.
Right.
That just seems to be the interpretation that's being given to it.
I like your language, but is there a more formal phrase, and maybe Senator Folden, you can help us out here, for cold case? Can we be more explicit? Like nothing in this subsection shall be interpreted to mean that it can only be utilized for cold cases, but that sounds a little informal to me. And I was wondering if there's a term of art for cold cases.
Basically, that all investigative leads at that time have been exhausted.
Leads would have to have been.
All reasonable investigative leads have been exhausted.
Okay.
I mean, that's,
Yeah, you could say that, and just say, like, have a construction provision that says nothing in subsection E shall be required.
well,
Reasonable.
so if you look at the fiscal note, and when you look at the last line of their brief synopsis, it talks about that the prosecutor from the relevant jurisdiction asserting that the identity of the perpetrator is unknown, and then they're saying that instead that reasonable investigative leads have been pursued and failed to identify the perpetrator.
Yeah.
So it's like, it's the same thing. I mean, I think that's exactly what we're trying to say. We just codify it, I guess. Is that what we're? I mean, that's almost exactly the language that we just discussed, is all I'm saying. So I think that's what we're trying to accomplish. I think that's the intent of it, so.
That last part of the summary is actually the language that's being removed from the statute. So the current statute,
It's on, look on the page, top of page.
right, it's at the bottom of page 2 and the top of page 3. One of the requirements is, unless it's a ongoing threat to public safety or national security, that reasonable investigative leads have been pursued and failed to identify the perpetrator. And so that, what the bill's doing is it's taking that out and instead requiring that the affidavit say that the identity of the perpetrator is unknown. And I think that's where the confusion in the existing law is coming from, is they're thinking they have to go all the way, like, and there are no other investigative options.
So can we say
left.
that the identity is unknown in all reasonable investigative?
They want to pull that out, because that's being taken to an extreme.
Right.
Or all reasonable investigative need, or, I don't know.
I think they want to take that out because that stands.
That's kind of where they started.
I think.
I thought you guys were just trying to clear it up.
But
The county is misinterpreting the law that we already
have, and we have to find a mechanism.
That gives the clarity, but it's not saying everything has been exhausted. It just says all reasonable
And I think that's kind of the idea, is
Correct.
clarifying language to say, like, you don't
who it
mean
is.
every investigative lead. You just mean that you want them to have taken some reasonable
Yeah,
investigative
that there's a reasonable
leads.
investigative needs have been exhausted and the perpetrator is still unknown.
Right.
But the problem is that.
The current language is even more elastic. Current language is reasonable investigative leads have been pursued and failed to identify. So it's kind of even more elastic than what you're suggesting.
I would say keep that.
That's what I'm saying.
Yeah.
Yeah, just pull the brackets out.
concerns and reasonable investigative leads have been pursued.
I think, let's just pass them. That was it.
All that much then.
We're not really trying to change all that much. We're just trying to change someone's misinterpretation of the law because they're interpreting what apparently is the letter versus the spirit. So we're just trying to find that one or two words that is necessary for them to be okay with it because we've got a murderer who's known, who was found in a database who's not eligible to be prosecuted because of their poor interpretation.
I think additional construction language might be a good way to draft that in, but, you know, obviously defer to.
I like what the vice chair said before about nothing in this paragraph shall be construed to say that all reasonable investigative leads must have been exhausted.
If I were asked to draft a bill with that goal in mind, that is probably how I would start doing, like, that would be my starting point too, yeah. So I would suggest retabulating subsection B, which begins at line 15 on page 2, and create a new B1 and then sort of sub out all of those with new tabulation. And paragraph B2 would read, nothing in this subsection may be construed to require that a law enforcement agency, I think is the right term, that they're, that a law enforcement agency have exhausted all possible investigative leads.
Nothing in paragraph 4 may be interpreted to require that all investigative leads have been exhausted.
Right. In concept, and with the committee's permission, we may change the language a little bit.
All right. Is everyone okay adopting that amendment? Now the bill's before you as amended.
Yeah, nothing shall be construed to require that all investigative leads have been exhausted.
Now the bill's before you as amended. Is the motion for favorable with the amendments? Second. Is everyone okay being reported in the affirmative? Excellent. Okay. House Bill 301 passes unanimously with the amendment.
It's not on the voting list, right?
And no, it's not. House Bill 775.
House Bill 775 requires that whenever an incarcerated individual dies in a Division of Correction facility, the Commissioner of Correction must notify the state delegates and state senator representing the legislative district where the facility is located, the legislative body of the county where the facility is located, or the Baltimore City Council, the chief executive of any county where the facility is located, or the mayor of Baltimore City. And the notification must include the cause of death and may not include any protected health information of the deceased individual.
All right, there's a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 775 passes unanimously. All right, now we're going to go on to the Senate bill. Jamie.
Senate Bill 1007 authorizes a court to receive into evidence an intercepted wire, oral, or electronic communication, regardless of whether the disclosure of the communication would violate the state's Wiretapping and Electronic Surveillance Act if the following conditions are met. The contents of the communication and evidence derived therefrom are offered as evidence of a material fact. The interception was not made as part of or in furtherance of an investigation by state law enforcement officials. The contents of the communication and evidence derived therefrom are more probative on the point for which they are offered than any other evidence that the proponent can procure through reasonable efforts, and the interest of justice will be best served by the admission of the communication into evidence. Even if these requirements are satisfied, a court may not receive a communication into evidence unless the proponent gives the adverse party notice of their intention to offer the communication and evidence derived therefrom and provides the name and address of the party whose communication was intercepted. Notice must be given sufficiently in advance of trial or hearing or other proceeding to allow the adverse party a fair opportunity to prepare. There is one amendment in your voting packet. The amendment on page 2 of the reprint strikes a provision of the exception that would apply it to a trial, hearing, or other proceeding, or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or other authority of the state, and restricts it to being offered in a criminal trial or hearing before the district court or circuit court if the court determines that this is a case in which the communication is offered involves a crime committed against at least one individual. The other change that the amendment makes is on page 3 of the reprint, provides that the notice that was described in my summary needs to be given, let's see, it needs to give the adverse party a fair opportunity to prepare, but not later than 14 calendar days before the trial or hearing. And that was
I'd like to move the amendment so that we can work off the amended version of the bill. Second. All right.
The narrowing down or the deletion on page 2 from on lines 18 through 21 to just a criminal trial, what was the purpose?
Sure. Well, I can't speak to motivation for it, but I can tell you that the difference is that there were a fair range of proceedings that would be affected by the exception, and this is a narrowing to not only a court proceeding, but it would also need to be a case in which there was a crime against an actual individual that was at issue in the case.
It's been moved and seconded. All right. Is everyone okay? We've adopted the amendments. All right. Motions for favorable and second. Is everyone okay being recorded in the affirmative? All right. Senate Bill 1007 as amended passes unanimously. All right. Almost. Wait, let's do this real quick. There's two we're going to do. Sure. It's a Senate bill. All right. Hold on. And we do Senator Love, Senator James, Senator Folden, Senator West, Senator McKay, Senator Charles, Senator Sidnor. Pointy talk. Say what? Yeah.
All right, here's who I have. Love, James, Folden, West, Charles, Sidnor.
All right, we're now going to go on to House Bill, we're going to do 275, and then we're going to go on to House Bill 592.
House Bill 275 alters the definition of adjusted actual income under the child support guidelines by providing for the deduction from actual income of an allowance for support for each child living in the parent's home to whom the parent owes a legal duty of support if the child is considered to be spending more than 92 overnights in the parent's home, but who is not subject to the support order.
Tim, again, how does that work and what is it changing?
So this is, as I understand it, a situation in which someone has been ordered to pay child support to a child, but they are also having their care for these circumstances for at least 92 overnights in their home. They have a child who is not covered by that child support order. So it allows the court to take a part, when they're calculating the income that applies to the child support guidelines, it allows the court to make a subtraction for the support that the parent is already providing to the child who's not covered by the child support order.
Okay, that's something. That's good.
All right, there's a motion for favorable and seconded. So House Bill 275 passes unanimously. All right, we're now going to go on to, this is House Bill 59. Oh. House Bill 592.
It's at the very end. House Bill 592 prohibits a person from possessing a regulated firearm, rifle, or shotgun if the person is currently a respondent, subject to a court order to comply with an assisted outpatient treatment program. If a court orders a person to comply with an AOT program, the court must promptly report specified information through a secure portal approved by DPSCS. The bill takes effect July 1st, 2025, contingent on the taking effect of Chapter 704 of 2024. The bill terminates when the termination provisions specified in Chapter 704 take effect. There is one amendment in your voting packet. Let's see. The amendment strikes provisions of the bill and instead provides for a procedure that would enable a court, direct the committee to page 6 of the reprint, providing that at any time after ordering a respondent to receive assisted outpatient treatment, if the court finds probable cause that the defendant poses a credible threat to the physical safety of the respondent or another, the court shall order the respondent to surrender to law enforcement authorities any firearm and ammunition in the respondent's possession and prohibit the respondent from purchasing or possessing any firearm or ammunition while the respondent is required to receive assisted outpatient treatment under this subtitle. The court may rescind an order at any time if the court finds that the respondent no longer poses a threat to the physical safety of the respondent or another and is not otherwise prohibited from possessing a firearm under state or federal law. Before ordering or rescinding any order issued under this section, the court may review all relevant open and shielded court records involving the respondent, including those specified on page 6 of the reprint. The amendment also provides at the bottom, going from page 6 of the reprint onto the final page, that in accordance with provisions of the criminal procedure article, on application by a state's attorney or a law enforcement officer with probable cause to believe that the respondent who is subject to an order under this section possesses a firearm and failed to surrender the firearm in accordance with the order, the court may issue a search warrant for the removal of the firearm at any location identified in the application for the warrant.
like an outgrowth of the red flag bill that we passed a couple years ago. Very similar.
Drafting is actually very similar, and some of the provisions are identical, such as the search warrant language in red flag.
Okay, I've got two questions. First of all, what is outpatient treatment under section 10-6A-05? What are we talking about? What kind of treatment? Outpatient treatment. It's not inpatient, it's outpatient treatment.
Right. So
what is
that's a court-ordered form of treatment that the General Assembly established, I believe, last year through legislation. And if, let me just pull up the criteria for it. For assisted outpatient treatment, and there's beg the committee's indulgence while I read the list here. It's requires that the respondent be at least 18 years old. The respondent has a serious and persistent mental illness, which means a mental illness that is severe in degree and persistent in duration, that causes a substantially diminished level of functioning in the primary aspects of daily living and an inability to meet the ordinary demands of life, and that may lead to an inability to maintain independent functioning in the community without intensive treatment and support. Additionally, requires that the respondent has demonstrated a lack of adherence with treatment for the serious and persistent mental illness that has been a significant factor in necessitating either hospital inpatient admission to a psychiatric hospital for at least 48 hours or receipt of services in a correctional facility at least twice within the immediately preceding 36 months. Or alternatively, resulted in an act of serious violent behavior towards self or others, or patterns or threats of or attempts at serious physical harm to self or others at least once within the immediately preceding 36 months. Additionally, the respondent is found to be in need of the AOT order in order to prevent a relapse or deterioration that would create a substantial risk of serious harm to self or others. The respondent is unlikely to adequately adhere to the outpatient treatment on a voluntary basis, and AOT is the least restrictive alternative appropriate to maintain the health and safety of the respondent.
Wow, that's a mouthful. Okay, it does seem to make some sense. And my other question is, at the end of, what is this long paragraph at the end of the bill about when it takes effect? I can't figure that one out.
So the AOT process was established through Chapter 704, which was passed last year. So what this language is doing, and that actually has a start date and an end date. It sunsets, it begins, let's see, July 1st, 2025 is when that bill from last year actually goes into effect. And that AOT bill from last year, which is Chapter 704, actually sunsets currently in 2030. So because that procedure, that court proceeding for AOT only exists for a 5-year window, this is being paired up with that. So if the General Assembly were to extend that or make it permanent, this would continue
automatically
on.
extend?
Right.
Okay, that makes sense too. All right, thank you.
Thank you, Mr. Chair. So this doesn't, I didn't get the answer, I guess, that Senator West was looking for, because as I see it, this is still, there's a couple of issues with it, in my opinion. One is, it also requires a reporting to the NICS system. The bill is drafted does require. Which is for the national, what's NICS stand for?
Was it National Instant Criminal?
National Instant Criminal Background.
Right.
So we're going to enroll people into a NICS system for a mental health treatment. That's one. So now we're saying that they're criminal based just by the sheer fact that they're going to enter them into NICS?
Well, the amendment actually strikes that provision, Senator.
It takes them out of NICS?
It does take them out of NICS, but I would point out that mental health findings are already reported to NICS. So if an individual is found incompetent to stand trial.
Only those mental health things, though, but those are where they're unable to be criminally held responsible.
Right. I believe, and I'll double check for you, but I believe
This is a
that also
HIPAA type thing.
the involuntary commitment may be reported as well. I'll double check on that for you.
But this is a reporting for outpatient, not inpatient, which is, this is outpatient.
Criminalizing mental health.
So this is basically taking what I could just say, like, that's a well-intended, but a new approach to take away someone's right, their constitutional right, without any criminal adjudication, is of their firearms. No criminal adjudication, going to take their firearms. We already have the red flag law. If the red flags are the issue and the family member or whoever is the one that's doing the advocating to the court for this what is it, assisted outpatient treatment, whoever's asking for that AOT clearly should fall within the realm of what the red flag rule would provide for already, in my opinion.
Well, I think with red flag, I would agree that there's definitely an overlap there. That somebody who is involved in these petitions could potentially be subject to a petition for red flag. I think what distinguishes this would be that it incorporates this into the AOT proceeding without the need to file a separate petition. But that's just my explanation of it.
But it's still basically an expansion of a red flag rule without, it's expanding the footprint of the red flag rule.
To be safe from my character, I want to avoid characterizing it too much. I would say that it mirrors much of the language in the red flag law that exists.
Much of the language, and creates a new way that a law-abiding citizen who may or may not, and depending on the severity and depending on what court you're in front of and what jurisdiction you're in front of, a judge could then thereby, through this bill, they would take your firearms from you.
They would order surrender of the firearms. That's correct.
So it's, again, an expansion of the red flag law because it's actually getting broader, because now we're getting out, because this takes away a part of in the red flag law, it was very clear. Originally, it was really wide on who could petition. And then it got narrowed down a lot to, law enforcement, mental health or physician, mental health provider, doctor, whatever it was. And
I believe there's
and then
nine
family
categories.
Huh?
I believe off the top of my head, there are 9 categories of potential petitioners for red flag.
Are you saying that the way this is crafted, does this create?
No, this doesn't create a petitioner, right?
Okay, so then what in the current red flag rules, what is this accomplishing that we can't already do with the current law?
No, I think that, again, I want to be careful not to come across as promoting
But this is a
the
very
bill.
important issue, because what's being missed in this is, one, it's a mental health HIPAA issue for someone that is not incarcerated, not eligible hasn't met the threshold of not being held criminally responsible for any type of crime. Right? We struck out the part where we're going to record them into the NICS system.
So they would no longer be reported to NICS, that's correct.
So they're not convicted of a crime. And who's the petitioner in this? It just talks about the court being the adjudicator, right?
Right, so the court on its own motion would.
On its own motion, so who's?
So it would provide that if the court finds probable cause that the respondent,
probable cause from what?
That the respondent poses a credible threat to the physical safety of the respondent or another. So it's a little bit different than red flag because.
So this is saying to themselves?
Right, to self or others.
That's exactly what the red flag law is there. You're talking about the respondent
So
or the threat to the respondent.
The reason why I say it's a little bit different is because red flag actually requires only reasonable cause to believe. This actually provides for probable cause to believe.
So on the threshold, on the scale of justice, where is reasonable and where is probable cause?
I think that well, I mean, obviously reasonable cause would be on the lower end of the spectrum there. It would be a slightly higher bar.
So this is the higher bar.
That it's basically that you have cause to believe that they probably would harm themselves or another.
But if we already have a law that is a lower bar, why are we creating a new law with a higher bar to take from them unless we're changing who the petitioner can be?
Well,
and that's what the red flags laws does. It clearly defines who the petitioners can be. This seemingly allows someone else other than those 9 annotated persons to be the petitioner.
So what I would say is that, and I'm not agreeing with or disputing what you're saying.
Yeah, but I need you to speak matter-of-factly about what I'm saying.
That it is adding it to, well, it's adding it to the AOT position. I don't think
So it's expanding it. All right.
Thank you, Mr. Chair. Council, we struck out a significant portion of the House bill in favor of the language that you read. And as I understand it, the House bill language, it's already, you're prohibited from possessing a gun if you, I guess it's on page 5 in the portions that are struck out, lines 17 and 18. So existing law that already is, that you would be prohibited from owning or possessing a firearm if you have a mental disorder as defined under the Health General article. So what we're doing is putting some procedural guardrails in place for AOT, but the spirit of the law and what's happening, that's already existing in the law. Am I right?
So, right, and I'll just paraphrase a little bit. Under 5133 of the Public Safety article and 5205, which apply to long guns and regulated firearms, respectively, a person is prohibited by law from possessing any firearm if they have a mental disorder and a history of violent behavior towards self or others. So that's existing law.
Thank you. And then as it relates to the public policy of it, the layering on that you have to get to find yourself in this situation, severe and persistent mental illness, you are resistant to treatment, and then there's the independent finding that you're a threat to yourselves or others. Is that accurate in terms of the layering?
Yeah, I believe that's accurate.
Okay. I'd argue that that's good public policy. If someone meets that criteria of severe and persistent mental illness, they also are resistant to treatment, and they're a threat to themselves or others, why would we want that individual to have a firearm? I struggle to think why you would want that particular individual under that state to have a firearm when they are probably, because that's what probable means, probably a threat to themselves or others.
So I think it's good we're having this conversation. It's been a couple of years since we talked about the red flag law. My recollection, I think I'm right, I don't think there were 9 ways of getting it. I think there was the spouse, a close family member, which would include children, parents, brothers, sisters, and police, that's 4, and mental health professionals. who have been examining, have been working with the subject of the red flag law. So the reason why I think this bill is not difficult is because any one of those people filing a red flag complaint to get the person before a judge, one of the reasons why the primary reason why the judge in a red flag situation would decide that the red flag law applies and would order the guns be taken away is if the very testimony is introduced in such a proceeding that this proceeding requires to be introduced, namely that the person is definitely needs mental assistance, is resisting mental assistance, and is if permitted to retain firearms, would probably use them to hurt himself or others. So all this is really doing is oh, we're supposed to be on the floor? Okay, all right. We'll come back.